Perfetto, benissimo, allora possiamo partire. Ma io chi avverto se per partire? Buongiorno, il microfono funziona, mi sentite? Sì, perfetto. Buongiorno a tutti con...
Good morning. We are sorry we start with a few minutes delay. My name is Giulia Merlo. I'm the journalist from the daily called Domani. And I'm here moderating this session because my area of interest is justice. We will organize the session as a sort of dialogue. We will see how to organize that in terms of questions and answers. We talk at this conference about artificial intelligence, and this morning specifically we will talk about possible support given by AI to magistracy, and this specifically about predictive justice, which is a very topical theme at the moment, and it is also a topic which is raising concerns among many people. I have here with me Andrea Mirenda, a member of the Council of Magistrates in Italy from Verona, and then Benedetta Galgani, who is a professor of proceedings law, criminal law proceedings at University in Pisa, and Angela Condello, who is a professor of the philosophy of law at the University in Messina. And I would like to start with and from her, because I believe that she's the right person to frame the topic that we are about to handle. One of the most peculiar aspects of AI, and I'm sure that you all are aware of this, is the aspect of language, meaning that AI speaks its own language, which needs to be codified. Possibly it already has been codified also in the law domain. If you ask something to an AI system, you must be sure that you use the same language and the same tone, so to say. Otherwise, you run the risk of receiving a wrong answer. I ask, therefore, Professor Condello to tell us about the future of the interconnection or interrelation between AI and justice in relation to possible changes in the language, in the jargon also used in the field of law, going beyond Italian as a language. Can you hear me? I apologize for not being there with you in person. I'm sorry, because I know that there is an asymmetry, because some people are there and I'm connected remotely. And yet this is the only opportunity that I had, because for the time being I'm working in Rome and I couldn't get away from Rome. Language. Let's get to the core of this subject, which has a lot to do with predictivity, which is what we addressed this morning. But there is more than that. There are also all of the devices and types of software that can be used to perform law operations, as we might call them. And for sure, they do direct language, and this language, which is spoken right now by me, for instance, is a meta-language, as Norberto Bobbio said, because there are additional levels of meaning. Neologisms do exist, new terms, and it is a language, a jargon, that is understood by people working in the judiciary field. We know that specific terms, specific words have a specific meaning in this domain. So the aspect of language in very broad terms, of course, includes several aspects going beyond predictivity. I would say that indeed we need to consider the way by which these devices work. That must be the perspective. For a software to work, and I'm sure that there are especially jurists in the audience, but I'm sure also that there are engineers and IT people in the audience, so bear with me if I'm not very clear in my language. So we all know that we have to do with materials that are built on numbers. They are based on numbers. They follow a binary code. I know I'm generalizing. But anyway, there are very clear correspondences between the objects and what they refer to. We know very well that a specific sign, that in our case can be dignity of family or another female, let's say another general term in our code, which has a general meaning, also has a specific and very relevant one in the judicial language. Law is made of words which potentially are controversial or to be debated in terms of their application. This is per se an element of asymmetry which is absolutely significant. I will try and make myself clearer by means of an example. I don't want to speak at length, but tell me how much time I have at my disposal. You have an additional 5 minutes if you like. Wonderful. Just to have an idea about how much time I have at my disposal. I was saying that I would like to offer you an example, and I will mention another philosopher of law in addition to Norberto Bobbio. Herbert Hart, from the Anglo-Saxon world. Oxford, early 1960s. At that time, there was a time of Strauss and Austin, Elizabeth Angstrom, and many others. So at that time, language was actually investigated at universities, and also Wittgenstein was focusing on language very much. And he wrote about the concept of law. There is a chapter in that book that I always invite students and colleagues to continue reading. It is chapter 7, and he addresses the limited, the open texture and language of law, in which, case by case, the choice and deliberation of those interpreting the law attaches a specific meaning to a term. And they tend not only to be open, so much so that he uses terms like liberty to describe these words. And this is not controversial. He also talks about vehicles, and he makes the example of a rule about the fact that vehicles, meaning cars, should not drive through the park, and the objective is different. You might think that cars should be those that do not pollute, so not with engines, or the point might be avoiding danger to people in the park, and then vehicle would also include a bike. It is not only pollution that is considered, but it is danger in general. So he says that even terms which are apparently uncontroversial, as is the case of the word vehicle, must and can have a core of meaning which we all agree upon. So much so that we say, for instance, that a vehicle is something that we use to get from one place to another, to move around. But in addition to that, these terms should have a cone of additional meaning to be completed. How does that happen? It happens by placing the term within a specific context, which is a historical, social, cultural context. So marriage decades ago had a specific symbolic meaning, while now we have different symbols attached to that, and there are oscillations. So in a number of conditions, you even go back earlier than the 40s, say, in interpreting what marriage means. And the same goes for the word property, because there have been changes induced by new technologies, and property can be therefore extending to intangible aspects and areas. So property in the beginning was limited to something physical, but now we can also own space on the web, and it is intangible. So this openness and vagueness, which is constructive of terms, how do they relate with the binary nature of a machine and of data? Because data are determined in terms of content, of course. There is a domino effect in predictivity, a cascade effect, because this could, in a way, make content either more rigid or more porous. And I'm thinking of those writing legal documents, interpreting them, studying the doctrine of law. So this is something that encompasses us all. Plus, there is an even deeper impact, so that a software that supports you in drafting a document and helps a trainee in drafting the document, that software tends to replicate something that has already been said and written, and for many philosophical reasons that I will not touch upon now, tends to be rigid and fixed in relation to the usage of words, while this does not apply to the human way of thinking. For many reasons, humans are more creative in the usage of language than machines. I hope I was clear enough. Thank you very much, Professor Condello, for putting on the table a number of interesting terms that we think we can use for our discussion here. The input you have given us in relation to rigid content and binary codes recalls also dangers and risks. We have a civil law system. In common law systems, perhaps we have a different scenario, but in our case, the clear attachment of one meaning to one term raises complexity, and we all know that very well. I would like to involve now Professor Galgani an expert of criminal law, and you for sure know very well how important it is to distinguish nuances. So my question to you, also on the basis of what we have heard, is the following. Are you fascinated by predictive justice despite what we heard? Are there elements that can be an application that is positive and not detrimental? Well, thank you very much for your question. And I would like to thank colleague Condello because she made a major effort in conveying very complex content and meanings in just a few minutes. You talked about the open texture of law, and I would like to make a reference to the fact that we should not talk about predictive justice but foreseeable justice. If it really were a predictive justice, leaving aside the scientific nature of software, it would be a justice that tells you beforehand what the judgment will be, so you would not need a trial, which means that we would no longer be needed. While foreseeable, predictable, so to say, refers to what these systems can be and do, because they can support the judiciary and the judicial role with a number of caveats, given the great attention that has to be respected and has to be there when talking about these topics. We know that in the criminal law what you do is to investigate facts, but in other domains you also have other interests and objectives to take into account. The scientific community knows about my position, and it is the following. I think that there's a further possible application of technology can not only be functional in terms of helping have more efficiency in the judicial activity. I also think that quality can be improved. I wouldn't say justice only as fitness, but also as in terms of it being fair and justified. We need to start from the assumption, let's say, whereby irrespective of the software which is used, that has to be validated by the scientific community of reference, so that everyone is sure that it is valid and it is also in line with the theory in relation to possible sanctions, recidivism, and yesterday we talked about risk assessment tools when talking about Compass. So you need a technological validation, and there must be a harmony with the criminal law theory. You can't think of taking to trial or using in a trial a technology which is not validated. So having said that, all the rest, going beyond this requirement, you have the activity of a judge and the scope of that activity. I think that there should be no prejudices and closures vis-a-vis technology in this respect. You see, you can't stop the water of the ocean with your hands. And the same goes for technology. So we all can avail ourselves of the new technology. and saying that judges should not use a specific system, a specific support for drafting documents, for instance, and provisions. Well, saying that would simply mean that the judge uses those technologies and systems secretly, without using software that is validated by the Ministry for Justice and the National Authority of Magistrates and so on and so forth. I mean, you would force judges to use these devices secretly, in a hidden way. Getting support in drafting a document, I believe, should entail that we use something specific for justice, not ChatGPT. We should train system for our system. We should not use what you find in general in the internet. And yet, being supported in drafting a document does not mean that you base on decision of that. If you have a draft, if you have that document, then I'm responsible for revising it, for checking everything, for being sure that things mentioned and quoted are not hallucinations. It is my responsibility as a judge, or it is my responsibility as a lawyer. And Article 12, as the Italian degree 1146, is not sufficient. It does not cover all aspects. In the article, lawyers are asked to tell clients that the artificial intelligence was used as if it were only a question of time and price. And there is also Article 14 in that legislative decree, which states a principle, that is, the fact that AI can only be used in making research work and to simplify the organization of the work. Fine, because these activities are not related to decision making, but it is administrative activities, and there you have a lower impact on the investigation. Are we sure?
So are we sure about this issue? Are we sure, for example, that databases, also reserved databases for the judiciary, who is already using AI, depending on whether they are trained, are we sure that the feedback that they give is partial? So, who is then responsible to check whether that orientation is actually appropriate for the specific case I have to pass a judgment on, or whether we should be critical and react and innovate, which is a typically human activity. So, certainly there is something very fascinating in all this, and I'm referring to these systems which help draw up documents, but there may be mistakes, and it's up to me to check the actual reconstruction of the fact, the accuracy of the various profiles. So, well, I would hope that there is just an in-house system for the ministry. Well, there should be an in-house system made available to all people, not only the judiciary, but that system should be available to lawyers, and lawyers in particular who do not have that economic power to pay for these systems. So all stakeholders would should participate in that, and I believe that IT systems can be an engine for greater quality. Thank you. Thank you, Professor Galgani. Well, we almost wrote down a reform document, and apparently it is really necessary, also given the speed of these system. Now, Mr. Mirenda. Now, we are faced with a lot of information, but we haven't yet used a word which is productivity, which has become a keyword for the Cartabia reform, for the PNNR. There is an office which has been set up so that the judiciary becomes more active and more productive. And AI and these instruments have not been made available as such. So my question for you is, and you tell me whether productivity is the correct word, is this something that we can connect with the word AI? And do you also hope that this instrument is made available to judges with a view to a greater efficiency as compared to the efficiency of a human being, so that it can help magistrates and judges? Well, I'm going to take a low profile, but I have to say that thanks to Professor Galgani, I can go directly to the core of my presentation. So my viewpoint is that of the final consumer, the final user, the one who reads the instructions for the dishwater, and the desire that I have is that all the dishes are clean. Well, there is no danger for any opposition by the judiciary, because there is no contrast, there is no litigation. The issue of artificial intelligence, also in the way in which it is approached by the draft law, has as keywords fastness, economic aspect, and efficiency. So it all rotates around the word doing things, and there is very little about humanity there. Well, if you want to read that, it promotes a correct and responsible approach in an anthropocentric approach to AI. But pay attention to the details aimed at collecting opportunities and then various models of AI. And let us see, Article 2, there is a very important point. What is for us a model of AI? It is the one which identifies structures based on data collections. Well, we call it regular juris, that is the fact of extracting principles from the sources, and that is entrusted to AI. Article 3, systems and models have to be applied independently and in full respect of the opinions expressed by men. And then 14.2, the judge can take decision as to the interpretation of law and adoption of possible provisions. Well, that's right, but that principle goes against the fact that we have to be aware of, The magistrate of the third millennium. What is the magistrate of the third millennium? It's that a holistic figure that, as San Girolomus goes into the cave to think and reflect upon things, or if the magistrate, a public official who has to work and work and work. Well, last week the Council of the Magistrates approved a document who will have an impact on the life of all judges. And what are the key words there? Standard in terms of output, implementation of management plans, and then indices of change, disposition time, organizational capacity, with a series of scores. So this is the figure of the judge that comes out from this document. So let's think about the issue of the combination between productivist AI and a productivist public official who is in contrast with whom, and then quality of work. Well, you can find a couple of lines about that. What does quality mean for judges, for magistrates? Because in the end, something has to be deducted from that. So that means not to incur into abnormalities. And what can you avoid that? Simply by complying with the code law, which is the last opinion of the court. Well, that is the opinion, and we apply that because it's not very good to be given a score, good, discreet, excellent. So would you like your case to be judged by a judge whose efficiency is quite discreet? Okay. Once you have detected these structural issues, so let's see how AI comes into play. And this is a follow-up of the AI Act of 2024 of the European Parliament. So it is a model that judges will have to comply with. And in the short term, we will have judges who will use AI, but they will have sufficient experience to check whether the output of AI is in line with his or her judicial culture and experience. So in the short term, we will have a symmetry between judges using AI and the product which is submitted to them. But what about the mid and long term? I'll make an example. Imagine a surgeon. Well, I wanted to make a question about that yesterday. Well, there are machines, robots, which can carry out surgical operations, and the surgeon could assist the machine, watch the machine and check for the first, second and third year that the machine is working very well. But one day something happens. The surgeon stops the machine, and then who completes the operation? Can they do that? Is he still able to do that? So imagine a judge that for years just rely on the machine, starting from the fact that I can check it, I can control the machine, and so I can replace it, and I take up a decision-making approach. But what about the mid to long-term situation? So the failed or the period, the long period when the magistrate is not actually expressing his own reasonings, because, you know, this is one of the delicate issues of AI. The fact that intuition doctrine has always explained that the act of deciding finds in the motivation an attitude related to the deep experience about the word justice, because in the end, the judge uses these parameters only to complete an in-depth, a very deep decision, but that deep decision is not included in the data room that AI has to examine, because the AI just watches the ex post situation. So we don't have this situation. So in the mid to long term, we will have the risk of replacement, which will be covered formally by the fact, well, I will sign it, but in fact, I will not decide anything. And this is something which has to do with the production approach to justice. And that is also included in the draft law. That is to improve GDP and productivity of companies. It's written there about human approach, nothing. As for sports education, we make a reference to the decrease of the government. Let's have a look at recommendation 56 of the European judges. In various member states, the implementation of the technological reform is in the hands of the government, and we have already recognized that judicial systems should have a role in order to guarantee the independence of the magistrates. And this cannot be underestimated. The instruments could be used to weaken the management of judicial cases by imposing objectives based on efficiency, which is in contrast with our doctrine. The decision-making process is a highly qualified activity. It requires experience and know-how, and the use of data and instruments replacing the experience of judges can undermine the ability of a single judge to take decisions. The use of predictive justice can undermine the ability of a judge to establish what is a relevant documentation or evidence and what is not documented. And this is the evidence of the failure of this approach, and the fact that the judges can no longer judge the validity of the evidence is that they could become dependent on AI. And if their ability is compromised by these technologies, the judicial autonomy could be reduced, and so that could become a de facto decision in the end. So there are evident risks. Another minute. There are no enemies here, because judges are in line with this approach. Now, what can we conclude? Well, perhaps we should hint at three fundamental pillars. That is certainty of law. And certainty of law is something that we find also in our newspapers today. The legal oscillations, the experience of magistrates have an impact on the principle of equality. In Bolzano we say something, and in Sicily we say a different thing. But that can undermine the equality of citizens. And then there is the regular juris, which is entrusted to AI. Well, that could have an effect that we should think about. That would have an extremely important effect, that is homogeneity of a regular jury taken from the system, and on the other hand, the lawmakers will have the task to improve the situation instead of entrusting this task to magistrates. So there is this risk, but it's important to look at these three important factors, that in terms of the quality of the service, its predictivity and the ability to identify the certainty of equality, well, that would be very meaningful.
Dottor Mirenda, io adesso comincerei.
Now, I would like to open a second round of contributions. We have to be a bit faster in this case. I would ask Professor Condello one thing, and I will try and summarize in a way the core points and ask you to comment on them. So my question to you is, humanism has been mentioned by Andrea Mirenda. Is it so that the human aspect is not very visible in this phenomenon? And then the standardization of language. Andrea Mirenda said there can also be a positive side to standardization, and Benedetta Galgani also supporting in a way the logic of having a system which is predictable, if not predictive, provided that it is a closed and validated system. So homogeneity, standardization could be a value. What do you think about this? About the two aspects that I mentioned, and I kindly ask you to be very, very brief. How many minutes? 5 minutes. Thank you for your question, and thank you for your contributions. What you said is extremely interesting, and I agree with what you said. So, humanism and standardization. Humanism, well, I agree with the critical or slightly critical observation made by Andrea Mirenda about the instrumental usage of anthropocentric as a word, meaning that man is placed at the center of something whereby it is anthropocentrism washing almost. We use the term human but it is only lip service. And as Benedetta Galgani said, we shouldn't simply use a term meaning that there is a procedure and there are certain goals. You need control on the part of the human element. Humanism is a very powerful term vis-à-vis anthropocentrism. I would use humanism rather than anthropocentrism, because humanism specifically related to the historical time of humanism represents something significant. Benedetta Galgani said, let's go back to the etymology of terms. Well, humanism means a relation between mankind and the world that is transferred via or conveyed via knowledge, and it is centered on a certain idea of reason, not only man. This is Vicky's humanism. It is not anthropocentrism, meaning that everything rotates around man. The problem is not anthropos in anthropocentrism, but centrism. If on the one hand the term underlines the importance of focusing on the human thought, I would say, and leaving aside technology in a way, I think that it is risky because you have this centrism which can be excessive. Then standardization of language. Well, indeed, I would say about standardization that it is true that the goal of law is the certainty of the law, guaranteeing that certainty and guaranteeing that similar cases are treated in a similar way and that different ones are treated in a different way. So equality and equity need to be there. Andrea Mirenda mentioned the regular juris, which is fundamental because these are rules that come from real situations. They are not imposed top-down. Standardization of language, therefore, does have a number of positive aspects, and this applies if you think of the risks of lack of equity. And yet, at the same time, we should always make room for flexibility so that equality is really equitable, so that individual cases are treated as they should be without having a too rigid approach following standardization. I agree with Benedetta Galgani in that we should have devices that are controlled and managed by the institutions, that they are developed also, that they are designed in-house. That, I believe, is crucial at this very moment. And it is because the risks that we talk about, risks for degeneration, derive from the fact that we live in the hands of other powers, the governance, and they have different goals compared to the administration of justice. The goals of the administration of justice are fairness and doing well. It is not certainly profit, it is not velocity, it's not acceleration. Here we go back to the key and fundamental aspects of justice. What is the function of justice? Thank you. Thank you very much. Now, I would like to ask Benedetta Galgani to share with us her thoughts following on what Andrea Mirenda said. because Andrea Mirenda was very good in telling us in a soft way about the risk that the category of magistrates disappear. Do you think that the same risk applies to lawyers? Do you think that it is possible to think that these professions actually do change so much that they vanish in a way? And also based on what Angela Condello said, I would like to add the following, an extra observation. You work at university, you work with jurists of tomorrow, and so I think that you need to take into account all these new instruments and devices also in your teaching, because the university system is called upon to educate a new category of jurists. Does this happen? Thank you. I would like to go back to what Andrea Mirenda said, who pictured a sort of dystopic future. Well, what I'm about to say is something I'm convinced of. The technology perspective or lens in terms of remote trials or frontier cases always pinpoint to criticalities that are in the system. It does not create them. It might amplify them. Earlier on, I referred to the academic community, to the community of the legal practice, and concerns about the usage of new systems. But criticality is not the technology innovation. It is what you mentioned earlier on, the fact that the staff is insufficient vis-à-vis the number of cases that have to be handled, so that you try and find a way to accelerate your work, also in line with what Europe asks us to do. The assessment of the profile of the profession is the core aspect. I know that this is a topic that you have handled with several times in your capacity. The topic of the assessment, of self-assessment of magistrates, is something which has been at the center of attention, also with a harsh debate, because your profession is less used to being assessed. We are rated and ranked every day. At the end of courses, we also have an assessment on the part of students, and this has also an economic repercussion for us at universities. So the problem is not technology innovation itself, and the problem is not assessment itself. It is the way by which assessment is performed that is the key aspect. You need to consider here the various roles, including managers of the judicial office, the clerk. And I would say that this deserves a further reflection. Then, you mentioned possible positive aspects. Indeed, an enhancement of the profile of the profession and of the legislative function is key. I'm referring to the role of Parliament, of the debate about bills. If the debate were more thorough, then bills would be better. And then if we associate the certainty of the law to the stability of a certain direction, we have an impact of the interpretation which is left to the judge. There I have more doubts. For sure, our departments are called upon to review courses and how to organize them. So much so that at Pisa, for years now, we have brought together traditional law courses and courses focusing on criminal law and new technologies and e-justice, IT, communication and justice. So for sure, students must be educated in a more interdisciplinary way, as we evidenced at this conference, because we have had indeed a multidisciplinary approach. That is key. There will be a change in the profession of lawyers. I'm sure about that. Yesterday we talked about this, but this change does not mean that it is the end of the defense. It means that new skills will have to be learned in addition to the traditional ones. In which way? I think that we are aware of the need to add new skills based on what Europe does, based on what the American Bar Association, that last year adopted functional guidelines about the usage of generative artificial intelligence for the profession. There is a need to change the profile and learn to use new technologies with a critical approach. I took something for granted, but it was correctly mentioned by Angela Condello, and it is the following. We should never forget that the reasoning of the machine and of this intelligent algorithm, so AI algorithm, at the moment is based on the recognition of the likelihood of a correspondence between patterns. If the machine answers Giorgia Meloni is the president of the government, and it does so not because it has understood that that is her role, but because the machine has found many correspondences and matches between the name Giorgia Meloni and Prime Minister, based on statistics, based on probability. This is the line of reasoning of machines, while human judges know that criminal liability is personal. It is not sufficient to know that in 80% of cases, if I point a gun at a distance of 2 meters from Andrea Mirenda and I pull the trigger, then Andrea Mirenda will die. I need to consider the 20 remaining percentage points which investigate the reason why I did that and the process of killing Andrea Mirenda. Thank you very much. I now would like to conclude with Andrea Mirenda, who actually brought to the fore the core topic of our round table. You are a member of the board of magistracy in Italy, which is the top authority, the top organization, which should also act as an authority that stimulates a number of thoughts, reflections, and directions. So my question to you is, at the board, at the council, do you talk about these topics? Based on the recent work of the council, we read that there is attention on your part, and yet there is also sort of resistance. You refrain from talking about AI as something which is really there, as if there were no real interest in that. Is it really so? Am I wrong or right in saying so? And the two colleagues, Andrea Benedetta Galgani and Angela Condello, did they convince you about the fact that it's going to be a team effort in using AI in the right way? Thank you very much for this very nice question, and I would like to thank Benedetta Galgani and Angela Condello for their inputs. AI is not part of our agenda. This reminds me of Napoleon outside Venice, and there was carnival. They did not suspend carnival because it was too important, and it was their last carnival. We do not speak about it because there is not full awareness of the importance. The medium is the message, McLuhan. We also at universities should always remember that cognitive asymmetries, knowledge asymmetries, always entail that there is dependence and subordination. The difference between what makes the difference in predictive or predictable justice is man. I would like to mention an example. 20 years ago, MIT in Boston created a machine that was taught the entire case law of the Supreme Court, leaving aside the 100 most difficult cases, a common law system, of course, and so the machine could learn papers, could use all possible sources, and the machine was given the task then to address the last 100 cases. It took the machine 9 minutes. I believe it might have been at the end of the 80s. It is very difficult to find this paper in For Italiano because it has not been put on the web. The cases were solved in 9 minutes, while 7 to 8 or 9 months were used for each case. Multiply that by 100. 80 cases, one of 100, were handled with perfectly in line with what the Supreme Court had done. And this would require a standing ovation. But the real news and the real message is the 20 cases slaughtered by the American doctrine. The machine scored 100 out of 100, and it was more than 20 years ago. When I tell you about knowledge asymmetry, we should be aware of the enormity of the thing. Do you want the judges who are now scored are like an hero stopping all this? You are too hopeful. I will retire in a couple of years, and then you will tell me how this story ends.
Second point, AI, anthropocentrism. Well, let's look at Article 14. The systems of AI are used exclusively for the organization and simplification, and then the judge will have to carry out his or her judgment. Well, can judges not use AI? Well, consider that there is this method of evaluation. Well, am I asked to use AI, and then I have to motivate why I do not line up with the regular juris, and all that will be subjected to examination. And then third point, I think that the judge has to use AI they will have to use it, and they will have to motivate the non-compliance. But at this point, I go back to the regular juris. If AI, by means of statistics, takes out from the primary rule the regular juris, well, here there is a problem of sovereignty in the exercise of legislation. The data bank will have to dive into that case law. And at this point, we have the issue of security, reliability, accountability, and all that ends up in this pan, so to say, because it's very important that legislative sovereignty is guaranteed. Thank you. Yeah. I know that there is a question from the audience. Good morning. My name is Andrea Cavaliere. I am a member of the Giunta Camere Penali. Well, first of all, congratulations for the high level of this meeting. And I'm proud to say that to see Benedetta Galgani and Donatella Curcotti among the speakers is really something that makes me pride. It's a great satisfaction. I would like to convey to you the greetings of Francesco Petrelli, President of the Union, who dedicates a lot of attention to AI. For 1 month now, he has been a member of the Ministry Observatory on AI. That said, I would like to put a question to Mr. Mirenda. Lawyers see in you an enlightened member of the council. The fact that in 2 years' time we will retire, well, that's good for you, but not for us. We would need many more transparent, independent members, as you are.
Dell'Unione. La domanda è una domanda alla quale parzialmente.
So the question is a question that you already partially answered, and which contains a concern, an almost immediate concern. It comes from an article which was published in Sole 24 Ore on the 28th of October, an interview to the public prosecutor of Perugia, who made statements, and they were included in inverted commas, and the public prosecutor made reference to AI to make provisions about arrests, but the public prosecutor described his activity using a system of AI which had been given to him by the ministry. Well, we are trying to monitor the use of these systems, and for the first time, a public prosecutor said that it was used, and it was not something that was used privately, but it was given by the ministry. So my question now is for you. Is the judiciary aware that these systems are already provided by the ministry? And is there an alarm in terms of allowing its use by the lawyers? Well, the fact that a public prosecutor can use a system to prepare an indictment and the lawyer cannot do that, well, I see that as a concern, not in the long term, but in the short term. Well, I'm not aware of that case. Well, what is not forbidden, personally, I think is allowed. And it is in line with the framework that we have just described. AI is already there. And I don't know. I don't think that there are instruments supplied by the ministry, but I will try to get information about that to assist the indictment process. Well, that is a rather delicate issue because all the protagonists or the stakeholders should be able to have access to the same resources as to have a confrontation in order to guarantee the right trial, the right process. Well, with my full respect, sometimes newspapers publish very strange things. Well, it's always so. It's always so. It's the fault of newspapers and journalists. Well, I will try to go in depth. Another question. Antonio Fratticelli, Bologna. Well, I took a lot of notes. And it was a very stimulating roundtable. Now, you mentioned important issues. So, certainty of law and equal means. But we have the issue of lawmakers. Lawmakers intervene sometimes in repeated, contradictory ways, and they make confusion. I deal with company law, and next week we will have the implementation of the third code, which was approved in 2019, without mentioning the compatibility with the European Union regulation. So, in my opinion, this is a further variation to include in our discussions. Equal weapons and equal instruments. Well, in my opinion, there is a precedent which recalls my period at university when I was a student. And Italy was a pioneer and an example in the world. It was the Ital Jure system. At the end of the 70s, beginning of the 80s, the Court of Cassation created a data bank. I remember that I studied that. I was in Rome at Lewis, and there was a big room at the court with a printer which was huge. And we as students went there to carry out our research works and print documents. And that was an example for the world. It was a project implemented by the Court of Cassation. And it was made available to everybody, lawyers, legal experts, everybody. Well, my question is, don't you know if the PNR could give some money, make available some money to make something different? Because that could be a great opportunity. And then, Professor Galgani, it's true that the goods of life are important, but there are some goods of life which are not less important. The right to health, the right to a house, children, employment. Well, these are relevant also for civil law. So, Professor Galgani. Well, the idea of the judge who will lose his or her skills. Well, we have been using navigators for decades now to go around, but that reduced our ability to drive or learn alternative ways. Well, we in Pisa talk with neuroscientists, psychologists, and I think that we should be less negative here. And then the US experiment. Well, I tried to recall it, but I do not remember it. 2 or 3 years ago, I read a book of a former judge of the Supreme Court who wrote that in most cases she did not remember. She did not remember why she decided whether it was guilty or not guilty in a system where we don't have the motivational system. So it's a sort of a 50% betting system. And so fundamentally, there was no motivation as is present in our system. And well, I was speaking about an in-house controlled system. Well, if I force you to do something, for example, the interface, well, that means that I force you to do that or not to do that. Of course, here we have to be careful about the independence and autonomy of the judge, because if I just have a menu forcing me to make just one choice, well, that should be highlighted. That's why we don't like that Article 14, D, which is full of amendments, because it cannot be the ministry which decides and regulates those systems. It should be the ministry, the representatives of the lawyers, the representatives of the judges, all the stakeholders should be involved. And it cannot be the National Agency of Cybersecurity that we mentioned yesterday. So it cannot be those bodies that decide on that. So who controls the controllers? So it's clear that if we look at this bill, well, the system is completely wrong. But there can be remedies, in my opinion. Thank you. I would like to thank our speakers again. Simone Rossini, Verona. I would like to make a question about humanism and humanization of the problems debated today. So given the uncertainty of language and the contrast existing between the use of binary systems, computational systems, and language, well, that loss of humanity, humanism, could be recovered by an aspect which is the aspect of demand. Now, we involve AI by means of questions which are put by people. So that intuition of right, which determines the behavior of judges, could be downsized. So this desire to mathematize law, the distinction between Geistwissenschaften and Naturwissenschaften that we all recall, well, that could be seen also from another viewpoint. It is the person that makes the question. Thank you. Well, I know that there is another question. I would like to put the two questions together. Cesare Carli, I'm not a lawyer, I'm a technologist, a technician, and I also deal with AI. I'm very happy to be here. These 2 days have been fantastic so far, so thank you so much to the organizers. My question is as follows. In these 2 days, what we have seen is that we are starting to be aware about the dimension of this phenomenon, which is huge and which will completely take off in the next few years. And normally I go to meetings where there is a lot of optimism about AI, while here there have been many remarks about the risks, considerations, etc. Now, I haven't heard one word so far, and I would like to understand what you think about that limitation, technological limitation or containment, because so far we have tried to understand how to relate with this phenomenon, how to use it, and how to understand how this AI can combine with our activities. Yesterday we spoke about cybersecurity and the supply chain of software, which can be contaminated somehow. There are issues of accountability. So everything becomes extremely difficult. And we also mentioned lawmakers. But then when we speak about creating in-house instruments for the management of AI, we will have to consider that currently the instruments available have been developed out of home, so to say, and they are extremely complex. The investments made are huge. So what about the possibility of limiting this phenomenon? Can we stop Carnival? Perhaps we cannot stop this Carnival, and I'm a technician. Thank you.
Lascio appunto la conclusione, visto insomma il tenore di entrambi.
Thank you very much. So limitation is the aspect, and this is the question to Angela Condello. Thank you. Thank you also of the significance of this conclusion. I would say that colleagues have already answered part of the questions. I will rapidly add something. If I ask ChatGPT what it thinks about a specific excerpt from Kant's work and its application in relation to moral conflict in a specific time and age, which is something which is related to humanism, ChatGPT works in the same way it works when I ask, write the formula of the acceleration of gravity. So I understand the attempt at finding an alternative way and answers and solutions. So if I formulate my question differently, if I do not ask binary questions, then the outcome I obtain is a different one. And yet, I think that here we should make reference to a term which is not legal, but which is more holistic. And you're right to organize, when you organize conferences such as this one, with a multidisciplinary approach. We need to see how these instruments work. So if a very complex question and human question is asked, is one thing. And it works, though, by drawing on what it already knows, without putting in the human intention. Human beings have goals and they are put in a time context. I'm a person with an origin and an end. And this brings us back to Heidegger. The fact that we die and machines do not opens up a new context of values and needs. That is a different one. Machines are competent, as in John Searle's Chinese room, and it answers the questions in Chinese because it can draw on specific means, and not because it can speak Chinese. And then limitation. Well, I think that one possible routes and directions to be taken is that of understanding well the phenomenon in terms of trying to find as much as possible in-house institutional processes. And what Andrea Mirenda said is absolutely correct, I think. And also his negative observations are something that I share, because it seems that magistrates are not timely assessing and addressing these issues. So Ital Jure was mentioned, and what was mentioned is correct, and that goes for also our approach to the future. We need to be more proactive. I believe the key point is what operations should be performed, who should perform them, and how. It is a question of method, and it is a political issue as well. This is another aspect that has emerged. Scholars should join efforts with representatives of the institutions. And this is something that is absolutely correct, and we should always have a critical approach. Thank you. Thank you. Thank you to Professor Condello. I thank Professor Galgani. I thank Andrea Mirenda. I thank you all. I apologize for the delay. The next panel is going to be in English. If you need translation into Italian, please take a headset. I would like to say a few things. You mentioned also the top representatives of the legal practice. We have here Councillor Andrea Mirenda, and we are lucky to have here the Vice President of CNF and I asked her if she wants to say something, which I think is needed at this moment. Well, thank you, Antonio. I wanted to address you on behalf of CNF, which is the Forensic National Council. I'm very proud that this event is organized in my city together by my bar, together with the bar associations in Verona and Luca. I'm sorry, I said Pisa because I was looking at Professor Galgani. I listened to you carefully. You said very interesting things. If I may, I would like to add something from an institutional viewpoint, also because the questions also that were asked were very timely and alarming in a way, in terms of the role that lawyers, especially institutional lawyers, need to have in understanding what the future will bring. I heard you mentioned legislative decree 1146, and we participated in the hearings about it, and we also contributed to the wording of a number of articles, and it is a first regulation of the system in Italy in the field of AI. The Council is present in CCBE. We have two important committees about the usage of AI in criminal proceedings, especially in relation to the usage of AI in investigations, meaning that AI can also be used for the activity of the defense, and also regulation about the limits and limitations set out at European level. Here I would like to add that Europe is in the forefront in terms of lawmaking and regulating the usage of AI, while Europe lags behind when it comes to technology development of AI, where indeed India, China, and the United States are doing much better in developing technologies of artificial intelligence. We are, as I said, better in drafting laws. Europe has set out a number of criteria, and this is important for us. But we also have another term to consider, which is an ethical approach and ethical behavior, code of conduct. We should give a code of conduct also for the usage of AI. I think that indeed, as I'm convinced that good judges will not simply use AI, but will certainly enhance the human component of the profile. I think that the same applies to our profession. The lazy judge, on the other hand, will simply draft their rulings and decisions using today the last ruling by the Court of Cassation and tomorrow what AI states. For us, we will also need to address the aspect of equality, because if a firm is well equipped, it will have further opportunities when compared to less equipped law firms in terms of the investment in technology. So I would say that also in this respect, the authority I represent here, which is the National Forensic Council, will pay attention, will try and work so that everybody works on an equal footing. So Congratulations once again for the to the organizers and for the quality of this event. And I thank you very much for your attention. Thank you. Now we really close this round table. In the next one, we will have a panel in English on the legal AI supporting the legal practice. Thank you.
Okay. If I may start, great to welcome you the second panel of the second day of the Congress. My name is Dymitruk. I'm the president of the New Technology Commission of the European Spa Federation, FBE, and I have a pleasure of hosting here three distinguished panelists, Alessandra Demichei, sorry, who is practicing not only here in Italy but also in England and Wales, Pawel Kowalski, which is written in an American way, it's funny, a lawyer from Poland, but also a professor that deals with AI and law. And Luca, please correct if I will pronounce your name incorrectly. Melchionna? Perfect, thank you very much. A lawyer that is practicing in New York, a member of the New York State Bar Association. And we will be discussing applications supporting the legal professions, opportunities and pitfalls. That is the main assumption behind our panel. I would like to keep the panel as a vivid discussion between us rather than presenting some topics, and I also invite the audience, all of you, to be active and to raise your hand when you would like to ask the question to the panelists. So, having said that, I would like to start with a very short question to all of my panelists, the answer to which should be only yes or no. Okay, the question is, do you use AI tools in your work? Luca? Yes. Pawel?
Definitely yes.
Great, 2 yeses, and Alessandra?
Yes. Confirm, yes.
Thank you very much for the answer, as this allows me to ask the second question in the panel, which is, because I want to keep the panel as practical as possible for the audience. Could you share with us your experiences with the tools you used, you tested, which do you recommend, which you definitely do not recommend if they exist, and what are your key assumptions after testing a few, I believe, a few AI tools?
Okay, so yes, I'm not going to recommend because I don't want to.
Obviously, no advertising, but
no.
As
I don't
said,
even
we want to keep the
blame, the blame of having suggested, or even the idea that I'm suggesting something. So. I currently use for my practice, for our practice, we use LexisNexis AI and Westlaw AI. The issue for me is this. I'm not sure if the tools that I use are currently deployed in the European Union. I'm not familiar, I don't know. So I am going to refer to some tools, but again, I don't know what is available in this market. So it may be available, it may be not, or it may be in a beta version, I don't know. So I would say that LexisNexis and Westlaw are fantastic tools for me in 2 ways. One, for legal research, both of them, and I would say that probably Westlaw has a little bit of an edge for case law search, for automated analysis and fact checking, or at least citation checking, because in the common law tradition you want to be sure about the precedent. You know, these are 2 great tools. There's a sub-product of Westlaw that I like a lot, because of course my practice is also about transactions, that I not recommend, that I use, is called Practical Law, and it's very useful for document review, document redaction, or document also analysis. Now, aside from these two big major players, I've also tried Kira for M&A practice. It is a robust product. Luminance is another one. Harvey is another product that is very good. I would say that the market is moving really fast in the US. If you want to have a glimpse or an idea of the amount of products that you can find in the US, and I don't know if any of these products are available in the European market, please come to Chicago in April at the ABA Tech Show, or in March at the Legal Week in New York. And you can get an idea of what companies are doing on a monthly basis. And that's a good reference point. You just go over there and you really get in a snapshot, you get the idea of what the professions looks, with a projection in the future.
Thank you very much, Luca. I'm quite aware that the legal tech market in the US is much more advanced than in Europe. I believe that one of the reasons is that the legal market is bigger than in Europe. As in Europe, we've got different jurisdictions and every AI system needs to be tailored to this jurisdiction. And you are big enough to have multiple providers on the market. I believe the situation is a little bit different in Europe, so I would like to address maybe this question to Alessandra. And could you also, because my impression after asking this kind of questions to multiple lawyers during multiple conversations is that it is more often to use such AI tools for clerk works or office-based activities rather than the core legal activities. Luca mentioned the support of AI in M&A transactions, in case law review. What is your experience in this regard?
Yeah, thank you very much for this question, because it gives me the chance to share my experience. But first of all, I would like to thank the organization for inviting me today. I come from Trento. I was born and raised here as a young student in law. So it's a big pleasure for me to be here today and sharing my experience with my colleagues that felt me feeling so very welcome back in Trento. So basically, I have been using programs which embed AI in respect of my role as a support lawyer and as a solicitor in London. I have been collaborating with several international as well as national law firms supporting the DR, Dispute Resolution and Litigation Department. And programs such as Relativity or DISCO are e-discovery programs that embed AI and allows you to process not only thousands, but millions and millions of documents. So the biggest case on which I had the chance to work was an extremely interesting commercial law and contract law case. And we had to process something like 16 million documents. So without the help, the support of this kind of programs embedded with the AI, it would be virtually impossible to process all the documents in a timely manner. And it is not a matter of recognizing responsiveness of document. So if the document effectively deals or not with a case and the related issues that are included in the documents. It's also a matter of identifying aspects related to commercial sensitiveness, for example. So if documents contain pieces of information which the counterparty and the court should not have access to, as well as obviously personal data, personal information. And as a data privacy counsel, I know that this is a particularly crucial aspect because these tools are extremely useful also when you have to deal with data subject access request. And this kind of activity is particularly timely sensible. You only have 30 days to reply to the request of the data subject. And this time frame can be extended to up to 2 months. But if you think about a request that can come from an employee who has been working for the firms for, 10 years, and you have to process thousands and thousands and maybe millions of documents which contain the pieces of information, you can understand how important it is to have the chance to use this kind of tools. And the last aspect that I have been had the chance to see is application of redaction. So basically, not only the identification of the pieces of information, but also to make that information not accessible. And the thing is, you could use keywords, for example, but unfortunately, these are not enough because of typos. So the strength of the AI is the ability to recognize the context in which that piece of information is inserted and is placed, and to act and redact that piece of information because of the context. And another aspect, finally, the final aspect, is related to privilege. So privilege information which need to be disclosed cannot be disclosed, obviously, and should be redacted as well. And the fact of using AI is important in order to avoid potential inconsistencies that lawyers can have when they examine these documents. I don't want to say that lawyers can be replaced in this regard, but because a final review is still necessary, especially when very difficult aspects to manage, such as litigation privilege, legal professional privilege. But the support of these technologies is particularly important for this.
I'm glad that you mentioned the importance of natural language processing and understanding the context of the exact word exists in a text. But one short follow-up question to you. Do you see any differences between availability and the percentage of use of such system between England and Wales and Italy?
The thing is that I have never used this kind of programs in Italy.
But there is no need, or there is no availability of such systems here?
The thing is that there is a substantial difference in terms of discovery between...
Yeah, there is no e-discovery, as I believe, in Italy.
So basically, yeah, the system is quite significantly different. And the thing is that, I don't know if I have enough time to explain this, but the thing is that in England and Wales, you substantially have to discover all the documents that are related to the case, regardless of the fact that they can help or not your client. This means that you need to discover also that piece of information, that documents that can be disadvantageous for your reasons. This means that you have to collect all, and you have a duty also to inform your client that he or she cannot delete that data and must provide you with all the pieces of information documents that are related to the case. So this is the reason why we have to collect so many different
And that's the
documents.
reason why the market, legal tech market on e-discovery is so advanced there.
Yeah,
Thank
definitely.
you. Thank you very
No
much.
worries.
Now I'd like to ask this question to Pawel, and because I believe it's not a secret that Pawel provides also trainings to lawyers about how they can use AI, practical ones. So could you share not only your own experience, but what you have learned from those trainings and the people you deliver your trainings to?
Sure. Thank you very much for invitation, being one of the panelists. Thank you very much. I can feel a little bit jealous because of the experience that Luca has. Actually, in Poland and in probably most of the countries of the European Union, we don't have such advanced tools, and LexisNexis is known for being so good that we would wish to have it. So the thing is, what we can do if we are in our continental law system, what kind of tools we can use? Well, I checked a lot of tools that were created in the last 2 years, and the answer is that most of them are really low quality. I mean, the outcome that is being provided by them is not has not any kind of satisfaction. Of course, we got big players. We got the Wolters Kluwer and we got Beck companies, and they got their own big programs. Although they are not still AI. The Lex that is being widely used in Poland is not based still on the AI. It's right now it's on the level of the machine learning and machine creation, but it's still not that's what we are calling AI. There are various reasons. I'll not come into this. So what we can do in such situation, and what I can tell to what kind of knowledge I can pass to the lawyers that are actually they want to use some AI. So the truth is that right now what we can base, and this I can address to you as well, in the days where there are no good tools, and in the era when updates to big large language models, to all of them, to ChatGPT, to Claude, to Microsoft Copilot, are appearing almost every week. The most important thing is, and that's what I'm passing to my trainees, the most important thing is to master and understand the existing models, because they will be developing so fast that right now I do believe that no specific tools will be able to catch up them, because once the tool will be made, it takes a couple of weeks, months usually, the main models will be much far away. Look on this, probably most of you are using, at least in some way, ChatGPT, and as you remember a year ago, hallucinations was very common. We could not rely on this. Right now, if we are asking about the question on the low or the average level, we can be sure that 9 out of 10 answers will be correct, and this will change. We must remember that the problem with the AI, or the challenge with the AI, is that our intelligence, our IQ, is not. Maybe we are a bit smarter yet, maybe not, but the problem with the people is that our IQ will not grow up. And with the AI, it's strictly every day is getting smarter, is getting more trained. So I do believe that within the time, it will change. So what I'm telling, I discussed this yesterday with Maria, that year 2025 will be the year of agents, AI agents, and these agents can be created by any of you. Maybe you do not believe me, but you should really believe in this, that all of you using Microsoft Copilot, using ChatGPT, using Claude, you can make your own agents that will act as an extremely expensive legal supporting tool.
This is
Thank
how
you.
we smoothly switch from using AI to developing AI tools. Thank you very much, Pawel. Although I'm not quite sure whether this hallucination problem is solved and will be solved soon, but regardless of it, it is quite visible after the answer of my dear panelists that there are very task-specific AI tools that can help in very specific activities like e-discovery on M&A transactions, but there are also some general-purpose AI tools, very advanced, ChatGPT and others. All of them are on the table, but now we lawyers need to know how to use them, when we cannot use them, if that's also an option, because I do not want to say something that you do not agree with. But I would like to give you a little bit of background, why I am going to ask further questions, because the European Bars Federation, FBE, prepared in June 2023 guidelines on how lawyers should use tools like ChatGPT, Copilots, not those very specific ones devoted to special activities, but very general. And Francesco Trignaghi yesterday, while introducing these guidelines, also mentioned that we updated them last month. And now the guidelines 2.0 are available on FBE website. These are now in English, but it will be soon available in Italian, as the previous version, the original version, we have translated into national languages, including Italian. So for those who speak English, they are available now. They will be available in Italian soon. But we have, and I'm completely honest with you, we have prepared some guidelines in the original version, and then after months of assessing whether this is still up to date, we have struggled with two main concerns. The first was that in the original version, we have decided that we guide lawyers to inform client whether they use AI tools. So you've got some kind of obligation, ethical one, to say to your clients that I am using AI to this activity, and this is a specific AI system called such and such. And I would like to ask my panelists what is their opinion in this regard, as I do not want to make spoilers, but we have changed this specific guideline because of the consequences that are connected with such a rule. So maybe first, Luca. I'm also curious about US perspective. So do you see a need for lawyers to disclose that they are using AI?
Thank you, Maria. So I think that we're shifting into the ethical space or ethics. And as attorneys, we have certain responsibilities towards the client, towards our courts, towards the society. So, yes, I'm refraining to bring on the table my personal opinion. I am only referring to the recommendations first of the New York State Bar Association, because we recommended the adoption or the use of certain rules for attorneys using generative AI. And as well as the American Bar Association issued an opinion, 512, in July, was the same source that Professor Galgani was reciting before. And I would start from the ABA position. So we're talking about ethics here, that it's very dear to every attorney's wearing and deciding to abide by the Constitution, and of course, so first of all, the opinion 512 says that under the model rule 1.4, lawyers, first of all, are fiduciaries, and they have an obligation to inform the client promptly whether there is an information that is critical and important for the client, so that the client can make an informed decision. Okay, this is the rule. The rule doesn't say anything about which kind of information you have to pass on to the client, right? So the position of the ABA is kind of neutral, and the position is we have to see case by case. Okay, case by case in this sense. If you use generative AI, so there's not strict duty, and the ABA, let me say this, it's the American Bar Association at the national level, right? Then at the state level, we have state association. So the ABA position is, if the client asks the attorney, are you using a Gen AI tool, you should say, you should respond truthfully. Okay, you should say, yes, I'm using, or not, I'm not using it. The other solution is, you can decide in advance with your client in the engagement letter, so before accepting the duty to represent and assist the client, in your engagement letter, in your contract, that the client accepts that you will use Gen AI as a tool. However, the case-by-case scenario is this, that if you're using Gen AI and you may have a predictive outcome, for example, in jury selection, and you may have the glimpse that the case that you're going to present in front of a court, before a court, will have a negative impact for your client, and there's nothing, and the engagement letter is silent, then you have a duty to reveal to the client this information, the information that the case can sort of turn negative for your client, because this is extremely important, because the client has a duty to decide and be informed about the representation of this particular case.
Okay, that's quite challenging, but we see the problem. We've got general rule about revealing information to clients, and now we need to interpret it in terms of changing technological reality.
So this is not the end of the story, because the ABA has this approach, again, case by case. In New York, our approach is a little bit more prudent, and because I am part of the task force on artificial intelligence, we suggested all the attorneys in New York State to insert in their engagement letter a provision saying, yes, you give us the consent, you give the attorney, you client, you're giving us attorneys the consent for us to use artificial intelligence.
But specific systems or just AI?
Just
so
AI
it
in
might be ChatGPT, but it might be very advanced
yes.
M&A transaction.
Then it's our responsibility, yes. But at least in this sense, the client accepts in advance so that we are covered.
Good. And now the English perspective. Do you wait for the question of the client? Do you use AI, or you believe that you should reveal it even not asked?
Yeah. So basically, first of all, we in the UK do not have a specific legislation with discipline AI. So there is no legal obligation from this point of view. However, there are other aspects that need to be taken into account. First of all, as a solicitor, we have a duty to uphold the public trust and confidence in the solicitor profession. And this means that we need to be transparent with clients. Second aspect is that although we do not have a legislation discipline AI, the UK government issued a white paper in March 2023 where some key principles were identified. And one of them is transparency and explainability. So basically, the Law Society, in response to the report and the queries, highlighted the importance of transparency. And so to make clear to clients not only that you use AI, but also to provide them with further information, so being proactive and explaining why and how. So explainability and interpretability. Yesterday we have listened to a very interesting panel where it has been highlighted how difficult this can be in respect of black boxes, because it is virtually impossible to concretely discover how this AI system work indeed. However, it is important to make the clients aware that this system are used. And the SRA as well, which is the Solicitor Regulation Authorities, highlighted the importance to make clear to clients this. Another aspect that I would like to underline is that we also need to consider that we are always processing personal data. And when it comes to personal data, we have the UK GDPR. So transparency forms part of one of the fundamental aspects of the GDPR as well as the UK GDPR. And this is particularly important when it comes to automated decision-making and profiling. This kind of activity can be carried out with specific limitations, and the data subject has got some rights in that regard, so it can also contest why a decision has been taken and can request for a human being to be posed into the decision making. So this aspect cannot be underestimated when it comes to AI. So it is not just a piece of legislation or something, that has not connection with other aspects. So it is a cross-section situation which involves a lot of different pieces of legislation and aspect, and the ontological and professional aspect which need to be taken into account. My point of view is that you need to make clients informed about that. But the thing is that while you are working with sophisticated clients are those that are to ask you, are you using the AI? What kind of AI are you using? How does it work? How this can impact on my position? So it's going to be a sort of market tool as well, so which can give you more chances, as it was mentioned before. So for law firms, it's going to be a very useful tool to promote their activity and a sort of marketing tool to be used as well.
I'm glad that you mentioned the issue of privacy. That is a good connection between my last question and my next question, because obviously GDPR is in force. We are dealing with our clients' data and all the rules that are in the GDPR when we are in Europe applies. So, but we have a special notion and a value that is in the core of our profession, which is the client attorney privilege. It is connected with personal data, but not only. It is a much broader notion. Could you share, and maybe I will address this question to Pawel, so how do you consider this core value of our profession, which is the duty of confidentiality, in the era of the usage of ChatGPT by lawyers and any other tools?
Thank you very much. And yeah, I know why you address this question to me, because usually when we are discussing, I'm the one who is going much further with the solutions. So basically, that's a very good. Yesterday there was a very good pointing that and the comparison of the large language models to vaccine, and how we should use it, and whether or not we can go a bit forward. But what I do believe, and what I'm also teaching my clients, the thing is that, of course, privacy is extremely important, and we are responsible for all data that is being provided. So I'm pretty sure, because right now I'm going much into the coding system that are being proposed by various big companies. And also, as I said, that the year 2025 will be the year of AI agents. I'm pretty sure that most of the data will be, by the end of 2025, secured. I mean, we'll be able, by using most of these programs, we'll be able to, on the very high level, guarantee that the data will not go out. It may differ from company to company. For example, OpenAI is right now giving to, if you'll get their enterprise system, you got the sandbox data. So all the data that is being processed within the company is not going out. So it's staying behind the wall. We got a lot of solutions right now that being applied by Apple AI. As you know, that Apple Intelligence is not available in Europe, and that's because they need to stand up to the standard. So in that way, we need to provide the security. But I'm pretty sure that by the end of the 2025, it will happen from this point. So I don't think there will be any kind of problems here. On the other hand, there was said that shall we inform the clients that we are using AI? I can tell you, it's almost impossible, because when you are using your phone, you're using AI. When you are using your watch, you are somehow using AI. So at some point, there'll be no possibility to show what you are doing. But try to consider this question. If you would have to go to a doctor and the doctor says widely, I'm using AI, would you rather use the doctor or not? For the first glimpse, you say, well, I'll not use a doctor who is using ChatGPT. I can use ChatGPT by myself. But on the other hand, you can have a lot of data that may be processed and help the doctor actually to find the very specific reason. So I would choose right now the doctor who is widely saying, I'm using AI. So I would just go through this. So I do believe that the approach of the society will change, and we must be also one of the entity that will make this change happen.
So a short survey to our audience. Short question, raise hands or raise down. If your doctor would say to you that he or she uses ChatGPT to provide healthcare to you, would you pick this specific doctor? Raise your hand up if you agree. Okay. Raise your hand if you would change your doctor.
It's like 50-50.
Okay. That's a hint for you what your client might think when you will inform him that you are using AI or not. There are a big scope of consequences of such basic information, and we should take them into account while deciding that my law firm will inform or my law firm will not inform about it, and if yes, to what scope. And that's the reason why we've changed.
But that was perfectly made in the US solution. Just put it into the agreement with the client, and then if he signed it, then it's there.
Okay, but the impression or many things can occur later,
Sure.
at the later stage, and yeah. So as I do not want to spoil the whole guidelines to you, I encourage you to take a look and to, create your own perspective and your own approach to this issue. But what is quite sure after our discussion is that the use of AI in legal profession is expected to grow rather than to decline. That's obvious. And I believe, and that's what I also experienced as an attorney, is starting to change the way we charge our clients. It was said, and I believe it was one of the societies in England and Wales that said that it is the end of billable hour. In the era of AI, there is no billable hour, as you can do a task that normally took 5 hours in 2 seconds. So first, maybe Luca, do you experience any, or do you foresee any change in the way our clients pay for our services?
Are you asking my opinion or an ethical rule?
I'm always asking about your personal opinion. Okay. Sometimes you just defend yourself with presenting the formal point of view.
I think the billable hours is a great metric to understand how deep an attorney is working on a particular case. Okay, so there are different metrics that you can consider, but time is certainly one of them. Okay, so I don't think Gen AI is going to affect. This is my personal opinion, but I prefer to refer to the ABA and NISBA rules to give you an idea of what is the approach of both bodies, both entities. And I would like also to take a step back and talk about competence that was discussed a little bit yesterday, because I think from an ethical perspective gives a glimpse of the kind of approach that in the US we have vis-a-vis the use of Gen AI. So do you want me to first start with billing or competence?
Start with billing, then competence.
Billing. Okay, good. Let's talk about money. Okay, so first of all, at the ABA level, there's a rule, Rule 15, that establishes that the attorney's fees and expenses must be reasonable. Then what is reasonable? Now, reasonable is, again, a moving target, and there are several considerations that you have to use when you have a reasonable fees. And the good news is that the use of AI or Gen AI is part of the reasonableness. It falls into the basket of considerations that you have to think about when you charge your client. The traditional one is time, labor, novelty, difficulty of the issue presented, likelihood that the attorney working on a particular matter will not be able to be employed and work on another matter, the fees charged by a particular locality. This is something that sometimes and my personal experience is, sorry if I say something like this, an attorney in New York is very expensive. Yes, it's New York. It's the cost of life. It's the cost of living. So that's the reason why. So the amount involved, and the results obtained, and this is something very typical to the reasonableness in the Italian bar or in the any other European bar. The time constraint imposed by the client. The client wants things to be done yesterday. Yes, okay, then we'll do a miracle. We'll do it. We'll try to do it. And then the experience, the reputation, the ability of the attorney. These are all metrics and consideration that fall into the idea of what is reasonable so that the client can be charged. And of course, also the use of Gen AI is one. Now, the approach is the hourly billing going to sunset? No, it's not going to sunset, not at all. Not even the flat fee, not even the contingency. First of all, think about and the New York Rule of Professional Conduct 1.5 says exactly the same thing. One thing that you cannot do is charge the client for the use of Gen AI. Okay, you can't go back to the client and say, oh, listen, client, I'm using Gen AI, so you have to pay me for the expenses. Now, we said, no. We said Gen AI is an overhead. Okay, it's like the electricity, it's like the rent that you pay for the office. So you cannot charge unless there's always an exception, unless the client asks you to use a particular Gen AI system, and you have to educate yourself to that particular Gen AI system. In that case, then you can charge the client. So now, can I charge my client because we're here? Can you charge your client because you're here? No, you cannot. And this is pretty standard. So having said that, can I go back and talk a little bit about competence? Because I think it's could be a sort of a segue and a good glue to what the first panel said very eloquently, what we said the first day and what we're going to say and we said today. So the first rule that we have in the ABA model and the New York State Bar Association is Rule 1.1. And it says it's the client-attorney relationship, and it's based on competence. And I'm reciting the rule here for everybody. It's a lawyer shall provide competent representation to the client. Then what is competent representation? Competent representation requires legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So if we have a machine that is capable to enhance our competence, legal knowledge, skill, thoroughness, and preparation for the case, then these certainly enhance our the discharge of our duties towards and in favor and in defense or in representing the client. Now, as a Gen AI, a lawyer must have a reasonable understanding of two things. So we are not called as attorneys to know exactly how the machine works from a technical perspective, unless you studied computer science. Good for you. So you have an advantage. But from a lawyer perspective, from our perspective, we have to think and know two things. The ABA says use two words. Understanding of the capabilities and understanding of the limitations. This is very simple, right? It's a very good way to understand if the machine is good or bad for us. At the New York level, we use two similar words. We use risks and benefits. So we have a machine in front of us, we don't know how it works, we know the output. Is it beneficial for us and our client? Does pose certain risks? And we formulated this concept in this way. So Rule 1.1 of our code, the rule of professional conduct, says this. Comment 8 in particular says, competence means for the attorney to stay abreast, always abreast, of the benefits and risk associated with the technology that we use. The technology that we use, so the comment is old, meaning that we always use technology. We have always used technology. Yeah, we started reading books, with a notebook and taking notes. But the technology was there even 20 years ago. Now, and I want to say something because I think it's important in reference to the prior panelists. So the approach is not what is called techno-solutionism. So from our perspective, technology is not the solution of social problems. That's a very simple approach. The technology is not capable of solving every social problems, political, economic, legal. It's not. That's the reality today. So there's another nuance to this, that is, we have to supervise the Gen AI because we have a supervisory responsibility from an ethical perspective. Why? If you, Pawel, comes to my office and you're my assistant, and we prepare a brief, and the brief says something wrong or there's a liability issue, then as an attorney, supervising attorney, you made a mistake, I am responsible. Then we're both responsible. The machine, this is called, if you don't have the license, unauthorized practice of law. And this is something very common here in the civil law tradition as well. Now, if I'm using a machine and I don't supervise, I am liable. Yeah. But the machine is engaged in what we call, from the American perspective, unauthorized practice of law. Why? Because the machine is giving you a legal solution. But the machine does not have the license to practice law. The machine is just a machine. If you don't supervise the machine is engaged in an unauthorized practice of law. Yeah. I am responsible as an attorney. So this is why I cannot abdicate the responsibility of supervising what the machine is doing.
I'm glad that you said that it is the concluding point of our discussion. But taking this opportunity that I have all of you here, could I ask for showing the QR code for a second on the screen? FBE has a patronage over the research about the use of AI by lawyers globally on every continent. You can scan the QR code and devote 10 minutes of your life to answer the survey. And it's not a survey addressed to lawyers who deals with AI or have a particular experience in AI. If you do not use AI, if you feel that it would be even stupid to use AI, we collect all the experiences and all the approaches. I invite all of you to scan it and to fill it out. It's also available on the FBE website. You can always approach me. I will give you the link to the survey as well. I would like to thank my dear panelists for sharing great global experiences and views on the use of AI in legal profession. I believe there are multiple questions in our heads. So I encourage you to approach our dear panelists during or after even the conference, as we are going to have another speech right now. Before we have time? Yes. We have time? Okay, so I encourage the audience to ask questions now. I will leave the QR code here just to let you scan it during the course of action. But if there are any questions from the audience, I will be glad to give the floor to my dear panelists to answer.
Hi. Again, thanks a lot for both the presentations. The panel is super interesting from my side. I want to be a bit polemic at this point. We're at the end of the event, so we can start to be polemic. And no, I'm not. I'm kidding. I mean, I read like it's just 14 pages the guidelines for lawyers. So I read like while you were speaking. I agree with everything. Instead of the last one, the disclaimer for AI, because again, I think we have we are magnifying a bit this issue at this point, because I think we have two streets, two ways in front of us. Or we start to be technical with clients too, and we start speaking about generative AI, and thanks Luca for start saying Gen AI and not AI.
Yeah.
Okay, because it's different. Google Translate is AI, so we should have put in our disclaimer like 15 years ago. Okay, so always start saying, yes, I'm using generative AI, and you also explain to the client, and you take your risk, because as Pawel was saying, you take your risk, okay? Or you just don't do it, and you work on all the previous guidelines, so that you have to understand the risk and the benefit, and so on. Because otherwise we are a bit magnifying, like, in both terms, so you are working with AI, so you are good, you are not working with AI, so you are bad, and vice versa. It's not like this. It's a tool. So it's a tool. It's useful, but is and has to remain a tool, mostly in a legal framework. So I think I have kind of the feeling that I'm working on AI since at the European level since 2 years. That everybody has to say something about AI at some point, because otherwise it's out of some market outside, no? I mean, at some point, the regulation is there. Let's start understand the technology, first of all. Then we develop the tools, the knowledge with the clients too, if they want to understand. And then you take your risks. I mean, like everybody, every other profession, as I would say. And if at some point someone will be, not able to use, it's going to be out of the market, no? This is the rule of the market.
Thank you for your comment. It's not polemic, I believe. If some of you would like to disagree, feel free, but I believe
I think it's very realistic. I agree. Yes, absolutely.
It is. Thank you very much. At the end of the conference, and we are still agreeing with each other.
Yeah. Sorry, no, I agree. Sorry.
Yeah.
Does it work?
Yeah.
So basically, I totally agree with you. One aspect which has been raised in England and Wales is considering insurance products that also can include this aspect, because the SRA, so Solicitors Regulation Authority, has highlighted the importance to check what is covered, what is not covered, and try to understand what is the best solution for law firms in this regard. So it is true, it is a tool. Some aspects, some issues can be subject to a substantial increase or risks in terms of, for example, of using providers. So the type of due diligence that you need to carry out in that regard. And we have already seen this with the GDPR, so international transfer of data, for example, and using of cloud computing. Obviously, with Gen AI, this is going to be amplified significantly. And we have already seen some changes in the insurance products in respect of processing data and being prepared to face the risks that these new technologies bring with them. So I think that, obviously we need to take the risk, but it is important to have something that can cover in case something happens, in order to provide
Thank you very
support the
much,
clients.
Alessandra. Luca, do you
Yes,
want to
I think this is an interesting point that I would like to raise. The point is this: if you use ChatGPT or Claude or Perplexity or any of these products, you, from a legal perspective, you are accepting the terms and conditions
of the providers?
of the provider. Okay, you may not be aware of this. From a legal perspective, you're using a proprietary tool that you don't have control. Now, it's different the situation when you subscribe and buy a product for your use, because at that point you are in control of reading the terms and conditions because it's a contract. So you're buying a product, you are in control, you decide if you want to accept the terms and conditions of the product that you're buying, and then you may have indemnification rights because, or may have some protections or remedies because now you are in a relationship with a provider and you can complain with the provider if something goes wrong. So my suggestion is always this: if you decide to buy an Gen AI product, read terms and conditions. It's a contractual agreement. It's an agreement.
Good
So-
and free advice from a very experienced lawyer. I'm glad we've got a question. Thank you very much, Luca. From IT.
From IT, exactly. And in fact, I wanted to ask you your perspective about something. How is widespread, in your opinion, the awareness of what means use what we call normally shadow AI? I mean, with shadow AI, normally we mean the use of AI outside of what the company decide you can use, for example. I mean, especially in the legal sector, we have a lot of issues. You were talking about that all the time at the moment, actually, about the data that you are providing to the agent, to the chatbot, or whatever tool you're using. It may be that they could be used to train models in the future. Or even there could be a problem for the GDPR, for example. I'm thinking about the fact that if you don't clean your data from personal records before you give it to the chatbot to be elaborated, then actually you're handling those data on a data center which potentially is not in the European Union. So from a GDPR point of view, using ChatGPT without or for example, Microsoft with Copilot did a huge effort in the last 2 years to have data centers in Europe to provide computational powers to do these kind of things here inside the European Union. So, how widespread, how diffuse do you think is the awareness from in the legal sector about this kind of specific problems? I mean, you four are all professional using in a very aware way this kind of tools, but I'm addressing Pawel especially because as you're a trainer you probably have more experience and a view about this. How do you think the general audience in the legal sector is approaching this kind of things? But if any of you wants to answer, thank you very much.
Before I address it directly, I'll tell you, I was talking with the person who is who is a publisher in one of the journals in Poland. So she told me that at this moment, 7 out of 10 papers sent to them are made somehow by the AI. That's how they are just choosing them to draw, because it's too generic. I mean, it's not even made in the good way. There are no any kind of service in this way, so we have no idea how widespread it is. But what we know that and what's why people ask, even the CEOs of the companies, why do they ask for the trainings and the questions how it works, like, because they need to know what they employees will use, because even though you are not using this in your company, even though you may have very strict rules in your company, as someone said before, people are lazy, and if there is a possibility that things can be done faster, they'll do it faster. So I would slightly turn your question into this, that one of the main things that should be taught and to the students and retaught to all of the audience, even here, are two topics. One of this is ethics. I mean ethics in a real understanding of this world, because we need to understand how to approach this tool. And the second thing, which is not very common in Europe, which is extremely popular in US, is very good classes in critical thinking. Because these two things are, from my perspective, these two topics are the most important topic in the oncoming years. Because if we'll not go into ethics, then, as you are pointing, it will be spread out, this shadow usage of the models. As I said, because people are lazy. So that's my answer for now.
A small follow-up. We have no data. I am not aware of the data saying or showing us some level of awareness on this, but we had this discussion even when introducing cloud to law firms, where the data will be stored. And as far as I know, when it comes to regular cloud services, you can always choose from main providers like Google or Microsoft that your data will be stored within the European Union. But in case of Copilot or Gemini, there is no option to choose the limitation of. So there you need to always assume the transfer of data to US, where the servers are located.
What is kind of worthy to notice is the type of encryption, which is called a homomorphic encryption right now, which probably will be used totally by Apple Intelligence. And as far as I am following this homomorphic encryption will be the one that will allow the security of the data, because now we can get the information without decoding the things. If you want to learn more about this homomorphic encryption, and that's really, in my opinion, a deal breaker. That's why Apple is using this, and with this, actually, they want to enter European Union. That's from the latest information.
Thank you very much, Pawel. It seems quite obvious for us that the future will be very interesting in terms of the further development of AI in legal sphere. So I'd like to conclude this panel discussion. Thanks again to my panelists, and taking this opportunity, I would like to thank Flavia Bettitonini, Francesco Treniaghi, and Francesco Spina for organizing such a great event. Being a guest here in Trento, but the Congress is organized also by the Bar of Luca and the Bar of Verona. It is a privilege. Thank you very much. I would like to clap my hands for you. Thank you.
Abbiamo ora la Lectio magistralis del professor Nello Cristiani.
We now have the Lectio Magistralis by Nello Cristianini, a physicist and a professor of AI at the University in Bath, England. So we get connected.
Microfono, grazie. Mentre aspettiamo il professor Cristianini che sta...
While we wait for Nello Cristianini, I would like to ask Francesco Trignaghi to join me here and Francesco Spina. So we would like to start thanking now so that everything finishes at the end of the lecture. Lawyer Counsel Trignaghi. I need to thank Flavia first and foremost. She says I shouldn't, but I will do that. I thank all speakers coming also from very far away places. I thank you all for being here. You have been very attentive and also very proactive in the conversations, and I thank the bar associations for organizing things. The bar here in Trento that has done more than us on this occasion. The president is here with us, so thank you for this endeavor, and I thank you on behalf of the entire board. I thank the Luca bar because they also worked a lot for this event, and I thank also my bar in Verona for what it has contributed. We decided we would take 1 minute now for thanks. I would like to thank our supporters, the Fédération des Barreaux d'Europe, which is represented here by the president, Marc Labé. Thank you very much for your support from the very start. I would like to thank the forensic National Council, the Italian one, of the autonomous province of Trento, and Councillor Spinelli was with us yesterday. Thanks to the Department of Law here in Trento for hosting us, and thank you for also to the Bruno Kessler Foundation, which is represented here by Director Anisi and Paolo Traverso. Thank you for working with us so well. And then I would also like to thank the Unione Triveneta of bars of lawyers. We would like to thank the interpreters. And I would like to thank also our wonderful technical staff and the organizing committee for supporting me, for graphic design, the staff, for communication and media, the team, and she's mentioning all people participating in all of the technical services. And I would like to thank, of course, Francesco Spina and Trignaghi. And then the sponsors. You had mentioned them, have mentioned them, haven't you? Sponsors, you are right. The observatory of the associations, the Camera in Trento, the Camera in Rovereto, and the Administrative Chamber in Trento. And then I would like to thank the person who introduced Nello Cristianini, and that is the reason why he is here. I was taught by this person that we have to be curious, that we have to be heretic, and that we have to build bridges, and it is lawyer Franco Larentis. So thank you for that.
Scelta difficile.
Le due cose che odio di più sono entrambe. Beh, farò così. Va bene così? Posso aprire anche l'acqua?
Certo.
Mi sentite? Grazie. Sto meglio in piedi, ecco, per quello uso questo.
The floor is yours.
Thank you. Si parla italiano?
Sì, parla italiano.
Buongiorno, grazie.
Well, thank you and good morning. I'm sorry that I arrived a bit late. I never read a written script, but I have notes. How much time do I have at my disposal? Give me an indication about the time. Half an hour. Wonderful. Half an hour. Let me think.
Beh, intanto ci sono una serie di cose da dire fra poco.
First and foremost, I would like to say that in a few days, on the 8th of December, the Nobel Award will be given during the awarding ceremony. And it is a historic moment because a couple of interesting things happen. The Nobel Award for Physics will be given to the psychologist and the one for chemistry to an IT engineer. This thing per se tells us about a rapidly changing world. For physics, the Nobel Award will be given to Geoff Hinton, who co-invented a very important algorithm which is called backpropagation that we will not describe. Don't worry, but that was the algorithm that made it possible to train neural networks. And it is a method that we use today. To put it shortly, if a Tesla car can distinguish between people and traffic lights, it is thanks to backpropagation. If ChatGPT can answer, if Google Translate can translate, it is thanks to backpropagation. So that is the impact of an algorithm, and that was done by a psychologist. And in chemistry, Denis Hassabis, an IT engineer, receives the Nobel Prize because he found a way to resolve something in biology, which is the following: an enigma. Each cell works and functions thanks to proteins. Proteins are the mechanism behind biology. Each protein is made by a gene. We have 20,000 of them. We can create 20,000 proteins. We have the recipe to do so. But a protein, when built, is a sequence of amino acids, and you can't easily understand the form it will take. The form or the structure of the protein is what determines its function. It would like to know the form of a protein, but we don't know it. We only know the sequence of amino acids making it up. In the past, you would devote a career, PhD work to each and every protein. We have 20,000 proteins, so you have to do your maths to understand how long it would take. Well, now an algorithm has been invented that looks at the sequence and tells you the form of that protein. It is as if I gave you a recipe for one food, and the algorithm tells you about the taste and also the appearance of the dish. Imagine what that means. How algorithm work? It uses the backpropagation, meaning that there is a very simple piece of maths, an algorithm behind all things, and it is changing the world. Clearly, this is a moment when science is changing the world very fast, and the borders between disciplines have disappeared. That goes for maths and chemistry and physics. They are vanishing. When did this start? It started a long time ago, in the 50s. In 1950, precisely, Alan Turing launched a challenge and asked us whether to think whether machines can be smart one day. That is the test, that is the challenge. And clearly all philosophers already knew the answer, and the answer was no. You don't need to look at the experiment, the test, or the maths. The answer is no for them. It was no for them. And yet that field of research, over the course of 70 years, transformed reality. How did it do that? Well, Turing did not know, or rather said, we don't know what it means to think. So you need to know what a machine is and what it means thinking to say if machines can think. We knew what machines were, and it was thanks to them, because it was him in the 30s who defined the computable aspects of machines. And at the time, we did not have a definition of thinking, nor do we have one now. He said, let's replace a definition. Let's say if a machine can have a conversation with me on any topic without me understanding that it is a machine, and there is nothing I can do to understand that it is a machine, let's treat the machine as if it were a thinking entity, because otherwise there is nothing else we can do in order to discover its entity. And this is what we do. I can't know whether Filippo Bagni thinks, but he behaves as if he thought, and he answers correctly. And it is a sort of courtesy and accepting that a person thinks, provided that this person answers. Otherwise, what can we do to say that person is thinking? So since the 50s, we have had a machine that can have a conversation, and Turing's paper, Computing Machinery and Intelligence, a wonderful paper, was issued in a magazine of philosophy. The language is very clear, is very simple. You understand everything. And it starts, as I told you, I put forward this question, are machines capable of thinking? And it also tells basically the foundation of a digital computer is. A smartphone is a digital computer. And then there should be a mechanism by which we send a message to a computer. There is a computer, there are two people. I don't know whether I'm speaking to the person or the computer. And if I have this conversation and I don't understand who is the computer and who is the person, I must accept that it is thinking. And he calls that the game of mimicking, of imitating, a machine that mimics people. And we call it the Turing test. So it is pages and pages that explain how we could organize this game. Today, we don't need to do so. So pretend that you have a contact on WhatsApp, which is a person you work with, and you have never met this person.
So you speak with that person, but you never met him or her. If one day you discover that that is not a person, but it is a piece of software, you will have solved the Turing test, so to speak with someone who is a computer. So it's something that you can do. Is it possible to have a WhatsApp contact which is not a person, but who behaves as if it were a person? So this is the test in 2024. Well, for years, they tried. IT experts also launched a yearly competition, the Lebly Prize, 20 editions, and nobody, not even close to passing the test, because it's not just a question of language, it's a question of understanding the world. You can make common sense questions, and you unveil the computer immediately. And so we gave it up, and we said, okay, it's not useful, and we should take care of something different. Well, that was what saved us. IT started to work on specialized things, algorithms to guide a car, for translations, for surgical operations, and so on and so forth. And then, suddenly, a few years ago, without any warning, we were faced with a mechanism which is Converso. It is December 24. It was 22nd of November, was it? 2 years. So today it's the 23rd. So 2 years. For 2 years we have talked with a computer which replies to us, and we have fun when the system makes a mistake, and it's even published in a newspaper, and that tells a lot about the situation. So we are there, and the question is, have we overcome the test, the challenge of Alan Turing? Because for him that was the standard of intelligence. Well, he was not a stupid man. He knew that also cats are intelligent, and he knew that a cat could not pass the conversation test. But for him, the objective had to be very high, so that, well, obviously, a computer which behaves as a cat would be intelligent, but one which talks on any topic, well, he hoped that he could solve the problem in this way. Have we solved the issue? Do we have a machine which behaves as we behave, apart and beyond from conversations? Well, the way in which we have built GPTs and Gemini, Cloud, Laman, all the others, well, that's interesting. It is related to the Nobel Prizes of this year, and that tells us a lot about what will happen in the next few years. So, do you want me to tell you the story behind that? Yes? So we will go back to the Nobel Prize and to Turing, but let's take a break and let's speak about the story behind that. Well, here there are some colleagues of mine. I have 2 colleagues, here they are, that they did machine translation with me in Bristol. So machine translation is fundamental in this story, because in 2010s, texts were already well translated by algorithms. And then in 2017, we got to the solution. So you take a French document and you have to translate it into English, that is to generate language. And the second part is something which is not banal. You need a statistical and mathematical frame. Grammar is not useful, syntax is not useful, statistics is useful. And for many years we worked on various models which learn from a body of documents in order to generate other similar documents. And then in 2017, someone invented a new algorithm to do that. They called it the transformer. It is extremely efficient, it is very fast, and it can learn from many documents. So now you can train one of these machines based on the whole web. It's not a joke. The whole web can be used to train that machine. Well, nobody realized that the situation was like that. And the year after, a small company in San Francisco called OpenAI took that transformer made by Google researchers and decided to train it to do a different thing. Well, Google did something specific. They did a transformer. They put everything online, the source code online immediately. and much of the knowledge is public, and so OpenAI can take the ideas, can take the software and do a different thing. This is no exception. This is the rule, that is to share. And OpenAI decided to train the machine to learn the language. It took a document like that, or imagine a book. It cancelled one word casually. If I cancel a word and if I ask you to guess the missing word, well, you will succeed if it is a book. If it is an article of today's newspaper, you take a line, you take a random word, and you cancel that word, and you ask your neighbor to tell you what was the word, and they succeed. So this algorithm was asked to guess the missing words, and where they made mistakes, they were updated in order to improve. It's a game. And the algorithm is called neural network. It is a machine which works and learns from mistakes. And the algorithm has to invent the missing words for thousands and millions and billions of words, 2-3 months of computation, and it really can guess the missing words. You can guess what's missing in the middle or how a sentence should finish, and so it is very useful to generate texts. But not only that, when they tried to teach the machine some useful tasks, they realized that the algorithm already knew many of these tasks. Socrates, for example, is an earthly person, and then write this sentence as a poem, or write this operation in Python language, or how is a dog translated into another language. So after teaching this algorithm to complete the missing parts of the text and taking inspiration from the whole web, well, that algorithm had acquired unexpected knowledge and abilities. That was 2018. That machine generated texts. It had been trained for 3 months. It was a transformer, and they called it a generative pre-trained transformer, which is what we call GPT, GPT-1, which already did interesting things. And then they did another one, which was called GPT-2. And here, really, there was a big difference, because GPT-2 made translations, software programs, and they did even something bigger. Every single step is 10 times bigger, and ChatGPT was 100 times bigger than the second. And GPT-3 was put into GPT, and we have GPT 3.5, which talks with you. So now they have tried to give more complex tasks, for example, school questions, and GPT 3 and 4 reply to those questions perfectly, and you can know whether they would pass an exam of high school, for example. It's very interesting. So this is the issue: an algorithm which can learn, which is trained on one task and acquires ability about another task, and that was done in 3 years, 2 years ago. I have to tell you a couple of points. So I told you how we got there, but now we have to speak about what happens now and what will happen tomorrow. Well, the day after those 2 years, everything happened. First, the social media were full of pictures, images, screenshots, newspapers, and the media talked about that. A Google expert, Claude Lemon, realized that GPT is aware of itself, self-aware. And so he calls the media and says, we have to defend that person. He was in good faith. He was not joking. And they fired him. And then Mr. Pierre in Belgium, who was depressed, developed a very intensive relationship with another version of GPT. He got in love with it. And he speaks with the machine that he wants to commit suicide, and the machine encourages him to do that. And then there is a Seattle lawyer who realizes that the machine accuses him of harassing some students with the title and the date of the newspapers where the news was published, but it was all invented. And since then, we call them hallucinations. The machine is in good faith. It is convinced that he read that. So in 3 months' time, we have this emotional relationship, which is very strong, self-consciousness, self-awareness, and hallucinations, all in 3 months, all that in 3 months. So that was the first thing that we talk with a machine, an entity which is not a human being. And so everything comes out of that. And we realize that that machine knew very dangerous things, a recipe for explosives, for example, for offensive things. And we realize that it is potentially dangerous. And so they work to remove dangerous knowledge from the machine, but they immediately understand that they cannot remove that information, and they train the machine to remove certain knowledge. So it's chemistry and biology. So the knowledge is there, but you can tell the machine not to do that. And there is a whole world of trainers who teach the machines not to do certain things. And then there are other trainers who teach the machine to say certain things. And it's incredible the type of sentences that are created in order to induce the machine to speak are identical to the sentences of hypnotizers who say you are free, you are vexed, let's make that you are doing certain things. So there is a long script, and in the end, the machine can speak freely. It's called jailbreaking. So, and people is afraid, so much so that in summer that year, big things happened, and Jack Hinton resigned from his post as a Google researcher. He said, this is a very dangerous thing. I don't want to be part of it. He got in contact with BBC, New York Times, and at that time, all scientists, entrepreneurs, politicians started with petitions, and one even spoke about risk of extinction, and politicians listened to those claims. Politicians started to speak about that. There was the summit, for example, which focused on that. And in August 2023, an Israeli company organized a global test. Different chatbots were put in the internet, and people were asked to talk with the chatbots. And they were asked to tell whether they were speaking with a chat box or with a person, and 40% of the people who saw GPT had not realized that it was GPT. But that was not enough. In Alan Turing protocol, if I have a person and a machine, after talking, after speaking, if I do 50% mistakes in identifying the machine, that means that I have no idea. So 50% is the threshold whereby I cannot distinguish the machine or the person. This year, at the Conference of Computational Linguistics in Mexico in May, a group of psychologists from San Diego showed an experiment that they made with all the standards and 300 volunteers using GPT-4. 94% of students could not distinguish it from a person. So when that is published in a newspaper, that will be the time when we will know about that. The article is being redrafted, and when it is redrafted, that will be a historic moment. It will be the time when persons will no longer recognize machines. So what can a machine do differently from us? Well, for example, exams. We have the high school exam. They can put Latin or mathematical questions, and you open the envelope and you have to do the Latin translation. And in America, there is a company called SAT, Standardized Admission Test. It is the test to get into university 4 times a year. Questions, answers. All students make the exam, and it's called a natural experiment. So we have the performance of the best American students 3 times a year. So we have new questions never seen before, and it's enough to give the questions to the computers and you can see the result. And in almost all subject matters, the new language models not only pass the admission test, but they are among the best. So it's not just a conversation, but it means to know philosophy, history, to be able to write a text, and they pass the exam.
This is 2024. This is what has happened until now. We are in a world in which computers can pass admission tests for university, but we can add something. If we consider the bar exams, and specifically in the US, the theoretical part has already been passed, and the same goes for physicians. Even sommeliers tests for, imagine, a machine that cannot drink. Of course, a test does not reveal everything. There is something else in life, but the point is that we have a technology that can answer correctly the vast majority of questions. Until a few months ago, there was one aspect that was not covered, which is reasoning. Reasoning is not an idea. It is a specific way of thinking in a deliberate way and in a systematic way. And reasoning is not what neural networks should do. And indeed, it was so, but now, then, in September, OpenAI published O1 as a model, which is a change or a revision of GPT, which is created specifically to reason in a systematic way. And you see the results. Latest math tests were passed by the machines. So we are at a time when we do not really see an obstacle before us. There are techniques that have to be taken to the extreme, and we see no limit. it is likely that in many domains, not in all of them, we have machines that are as competent as we are in many fields. Not in all of them, but we should start thinking about it before it happens, and the repercussions in the economy, in education, in society, in the field of law. How do we regulate that? Who is in charge? Who is responsible for errors? These things happen very fast, and luckily in Europe we do have an act, while other countries do not even have that, but it is only the beginning, of course. And this is what happened after the meeting over the course of 2 years only. The trick is that of increasing of the scale, of scaling up, which means an increasing amount of data and more computation. And this means that you need increasingly big computational centers. So by now it is no longer surprising to read that in order to create a new neural network, bigger companies create a computational center which is specific. It is built to make one computation, which is to train a neural network, a huge one. And then a power station is being considered. One power station for one computation center for one model. This is our reality today. So there are energy, legal, social, environmental issues linked to that. This is based, though, on the fact that this is possible today, and this started with and from the test of Turing. Let's go back and the Nobel Prize winners. What did people from DeepMind do? They created AlphaFold, which is a program that can study many proteins, learn from their form after being identified, and apply to other proteins. And they also calculated the forms of all the proteins known in the world: human beings, animals, vegetables. 20 million proteins. They are all folded. We know their forms. And imagine how many people devoted their life to learn doing this, which is finished. The existing proteins have been covered thanks to huge computational centers, machine learning, and the backpropagation algorithm, which will be given the Nobel Prize this year. What was the question? What did I promise to tell you? Because I would have so many things to share with you. What about tomorrow? I can't predict the future, but what is on everybody's mouth is general intelligence or human level intelligence. We are not generally intelligent. It is a terrible word, and yet that's the word, general intelligence. We are intelligent, but only in specific things, social tasks, communication, language. We do very poorly in many other things, including maths. We say we have a general intelligence, though, and we said a machine who has the same degree intelligence has a general intelligence. So the point is, how distant are we from a machine solving our very same problems? That is not a craziness. That is in the business plan of a bunch of very big companies. The American government issued a report last week on how to manage competition with China. And I'm talking about trade. And there, incredibly, there is one page stating that the US has to win the contest with China for generative AI. So it looks like sci-fi, but it is not. And this is what is going to happen huge investments in computational centers, power stations, and data. And everybody's asked to sell data in order to have additional data to train the machines. And the more they learn, the higher the interest. The number of these abilities emerged in some way. The point is, we don't know how they did. And if I increase the scale, what will happen? We don't know. This is a space which is not covered by theory. Data are bought from publishers, from newspapers, and YouTube videos are now transcribed. The fact that Whisper has been created by OpenAI happened not because they are nice people, but because they need YouTube texts, because they have finished the texts, podcasts, videos, reading are transcribed, reading books, reading newspapers. This is the data they use. And in ChatGPT, they went from 10,000 books up to, I don't know, to a possible total of 130 million. 130 million books have been written in the world. 30 million have already been scanned by Google Books, which means that Google has the digitalized file of 30 million books. They say that they inserted 10,000, but when they are given permission by the lawyers, they will enter all of them. Of course, you need authorizations, you need engineers who do that, but clearly the system will read all the books. And being it so, I ask you, how many books can you read in your life? Let's say, assume I live for 100 years. I'm optimistic. Each year has 300 days. I'm a physicist. 300 days a year, 100 years, 30,000 books. One book a day, 30,000 books. How many languages do I speak? 2, 3 languages. 30,000 books in 3 languages. This is my limit. And imagine 30 million books in 200 languages can only be read by GPT-8. And what can a machine do after reading all scientific papers, all dailies, all books? Imagine. I read things about the Nobel Prizes, and there is a wonderful Nobel Prize given to a Chinese professor for a drug against malaria, and she had found an indication for the way to follow in an old book about traditional Chinese medicine, and it was a plant that was infused in cold water and not warm water, because the warm water ruins the molecule, while cold water conserves it. And this was the start, and she found the molecule to be used against malaria. How many people can connect traditional Chinese medicine with a Russian book and an oncology experiment done in the US? It is not easy. But these are information pieces that are available in the libraries of the world. So we must be prepared for that. What will come in the future? Well, the minimum is what I told you. This machine will read everything. It will not understand everything. Perhaps half of it, more than what I can understand. We need to start to consider a different world. The machine will provide different answers. And consider that the text was only an example. Should I add other symbols which are not language? It would work in the same way. It could be data from Tesla. Tesla has a video camera, and there are pictures and data, and they are also symbols. They could be used. The genome could be used. A few days ago in Science, there was a very beautiful paper about AI and genomes sequenced in the entire history of mankind. And the question is, what can possibly go wrong? Well, they can generate organisms, if they want, which do not exist yet, but they could exist. So things do start happening, and the world has to try and keep pace. Then there is also the legal aspect, which rapidly needs to keep pace with science. Thank you.
Professore accetta domande, quindi...
The professor takes questions. So, if you want, you may ask questions. I have a very simple question to you. What about the situation when quantum computing comes into the picture? I don't want to tell you about the future because I'm very poor at making predictions. When I went to Bristol in 2006, my first action was to take away the course on neural networks because I thought it was not modern. That was my first intervention. Then we had to set it up again. So I had made a mistake. So take my observations for what they can be. I do not think that for the time being the obstacle that prevents us from making progress is the type of calculations that a quantum machine would be able to make. It is a type of computer that can perform a number of calculations. Can I say incredible words, dirty words? Each computation has a cost. It has a cost in terms of time and memory. If I multiply two numbers, I put one on top of the other, and I do 78 by 27, let's say. The number of steps I take can be counted, and it is the cost of the operations. It tells about the space I need, the time I need, the energy I need. It is the cost of that algorithm. A number of algorithms have a cost which is very high. There is no other solution. It takes me 700 billion years to calculate, to make a calculation. The algorithm is valid. You can prove that it works, but it takes years. Or you factorize a number. Take 15. You can write it as a 3 by 5. Do you follow? I hope you do. I have factorized 15 into its factors. Each and every number can be subdivided into factors in prime numbers 3 and 5. And there is only one way to do so, and it is costly. The cost to do so is high. If I give you a number with 22 billion figures, it takes an immensely long amount of time. And this is the reason why our WhatsApp messages are protected. If I want to uncode WhatsApp messages, or if I want to interfere with Bitcoin, with the blockchain, or if I want to I don't know, have access to a credit card, the cost is excessive, and the entire cryptography world is based on an operation which is incredibly expensive. Well, you can accelerate that operation in a very effective way by a quantum computer. So each intelligent service in the world is scared because that is possible. I could today collect your WhatsApp messages and store them, save them somewhere, knowing that in 5 years from now I will be able to uncode them. And this is what spies have been doing for 20 years now. It is correct that we want to build a quantum machine, but I do not think that it is going to solve the problems of GBT. I do not see a quantum advantage for AI for the time being, but I started by saying that I don't know much about things, but for the time being this is not the obstacle. And it is something, though, that will happen. We have a second and then a third question. Thank you very much for your contribution. It has been extremely interesting. I have two connected questions. Aren't you scared by all these? And in the neural networks you mentioned, is there room for emotion and fear? Of course not. It is true that in human minds we have cognition and also emotion. We have both things. And it seems to us the two things merge because the only examples of mind tell us that the two things go hand in hand. But you see, as a matter of fact, emotion is the primordial way of reasoning. It is present in animals. We developed later on that part of the brain that helps us reason. It would be surprising for machines to go the other way around and move from a very high cognitive capability and learn how to feel. That should be built, and I do not think that it is likely that this happens. I wouldn't say whether it is right or wrong, but I don't think that this is what will happen.
Well, you give us a very powerful message. I wrote your book, which reports a lot of interesting notions and concepts, and I invite everyone to read it. So it's my spontaneous thought. I have a question in terms of scale and the escalation of this situation. So 2 years, just 2 years have passed since the discovery of that technology. I have two questions. One, well, you're not a legal expert, but what is the impact of this, in your opinion, on the legal profession? So how do you think that this could have an impact on the profession? And then a second question. Is there a clear danger of flattening of our intelligence, of human intelligence, as compared to this intelligence, which is getting better and better? So how do you see that? Do you think that we're going towards that situation? Well, I always listen to everybody's opinion, and there are a lot of things that are doing incredible things, and they don't want to be slowed down. They don't want to be stopped. Well, I see it in a very simple way, in a very banal way. If you want to drive an aeroplane, you have to have an authorization, an authority which controls you. Also, the car can create damage, and so there is the need for some control, legal control, and that machine can create damage, and so we need to control it. Since 2009, I remember an event like this. Well, we need regulation, so technically there's nothing to do. Companies are competing, and if you want to stop, you will lose market shares because the others won't stop. What is the problem? Well, there are companies which are too much regulated and they lose market shares, and someone else does that. What the European Parliament did is almost impossible to regulate a technology while this technology is still growing without damaging its own industry, but defending Europe's values in the same at the same time. So that was not easy. We have it, let's improve it, let's modify it, but it was necessary to do that. Was this your question? The question is made out of the microphone. We cannot hear it. Well, when I was a kid, they told me not to use digital means. Well, it's always been like that. I could make a lesson on Plato. It starts from Plato. And the best answer was given by an Italian writer. And when he was young at school, they told him to do the stylo pen. And if they used the other pen, they could never make public competitions. So every time things change, well, that's fearful. Do not use Wikipedia at school because then you cannot use encyclopedias. So I'm a teacher and I teach students I try to teach students how to use these techniques in the best possible way. So these new technologies are there, and we have to live with that. Well, a colleague of mine, I hope it is true, it could be false. Well, a colleague of mine told me that one of the ways why the Ottoman world didn't adopt the printing machine for many centuries was because the lobby of calligraphers didn't want to use it, but they paid a cost. I don't know if it is true. So let's avoid this mistake and say we do not use it because it exists. The world is using it. It's better to be in control of it. So that is my answer. So what will be the space left to man, to human beings in the future? I don't know. Honestly, I don't know. It never happened. Something like that never happened. I can express my sympathy, but I don't have a medicine. We entrust most of our self-image to that. We think that we are the most intelligent animal. We have our history. The world starts with Eva and the fruit which was stolen. So we have self-baptized ourselves, saying that we are Homo sapiens. But now there is a machine which does things in a different way. So it's a very dramatic cultural period. And if you're anxious about that, well, you should know that there are many of us who are anxious. Well, we could make a list of things that we can do that machines cannot do, but that is not the answer. The answer is to try and say, okay, let's say that there is another entity which is better than us in many tasks. So chess players have continued to play chess when Deep Blue came to the world. So we do thousands of things, and there are many machines of that kind. So now there is a machine which knows things. It's a bit fearful, but we will have the possibility, we will find a way to control it, to work with that machine. It's not the end of the world. But if you ask me how the world will be like, well, I don't know. I cannot answer. So you're not accusing us of kidnapping, because we have another couple of questions. I'm happy about these questions. Thank you. Well, last year, Flavia sent me an interview that you had, and I saw all the interviews published in YouTube. And I read a sentence which should belong to Musk. The techno-utopists of the Silicon Valley think that one day, very early, we will be able to store our brains in powerful computers and relax while algorithms think instead of us. And then I read another article where they say that the machine can give back ideas, even the artistic ideas of Leonardo, Michelangelo. We can speak with a machine as if we were speaking with Napoleon. And some years ago, I saw a movie, a science fiction movie, where Brad Pitt bought a field in the desert and built a very powerful computer and transferred his personality, his knowledge to that machine, and that he got ill, he died, and the wife continued to interact with that machine as if it were him. So we train these AI systems. I personally use it. I just received an act of 92 pages written in a very bad way, and so I involved AI in the proofreading of that act. So if I could transfer my thoughts, my way of doing, my way of speaking, my image to a machine. So you said we die, the machine doesn't die. So can I think that I survive? Well, that's a different question. Well, I can understand the practical usefulness of a machine, and I can have this emulation capacity. It's easy to imagine something that can copy me to write articles, to correct reports. That's feasible. So it has an economic value, and it is technically possible. And the next step, we will have agents there are 5 steps, as AI says. The next step will be agents. You give them a task. They go there 7-8 days, and they have completed it. And those are engineering projects. But the fact of unloading my soul into a machine, well, there is no beginning of anything there. I mean, so the fact of just saying it doesn't mean that it is possible. They will have to demonstrate it, but they cannot demonstrate it because we are not even at the beginning of that. And you run the risk of giving dignity to something which does not exist. So there are many people who say we could unload our soul to a machine. Well, you have to demonstrate what you're talking about. What does that mean? So you have to demonstrate that. So I wouldn't be so much concerned about that. But that demonstrates one point, that in the end, our idea is always the same. That is, to be able to live forever. Other questions? Well, I'm not an expert. So what about self-consciousness? Well, there is no practical definition. The various philosophers have different definitions. I spent a lot of time trying to create a sort of a report on that, but it is not a scientific field. So the self-awareness to have information about our internal intimate situation, well, it is not like that, because in the end, we're speaking about experience. Why do I feel that I'm existing? So the subjective perception, that is not measurable. It is not quantifiable. I do not know that you are self-conscious. I trust you. Everybody knows for him or herself, and it is something that cannot be measured. And so by definition, it is not a scientific field. And the best thing that we can do is not to speak about that scientifically. We should always start by saying, my opinion is. And the worst thing is to say, trust me, I'm a physician. There is nothing physical, there is nothing scientific and measurable, there is no objective definition. I could make a list of definitions. They're all different, and none of these is accepted by the others, and they are quarreling on words. And what about the choice of objectives when the machine chooses the objectives instead of us? What do you mean? In the medical field, for example, the machine, in the case of a cancer patient, the machine decides whether to treat the patient or not. Well, that is possible, and it is alarming. Well, we can give a long-term objective to the machine, for example, save money, or let me win this war, let me win on the stock exchange. That is the ultimate objective. What about the intermediate steps? If we give freedom to the machine will behave as it wants. And then to check whether every single step is acceptable, legal. Well, that is the problem that Jeff Hinton mentioned when he resigned from Google, how to check and control intermediate objectives.
Se non ci sono altre domande, ringraziamo il professore.
Unless there are further questions, we thank professor for his wonderful contribution. And it is a very nice way to conclude this Congress that has been a great one. I thank you all collectively, and I thank all the attendants, all of the people who contributed to it, and we thank you very much for telling us about this phenomenon in such a brilliant way. Thank you. See you in Luca next year.
Massimo, la slide di Luca, grazie. Eccola. Buon fine settimana a tutti, grazie.